Good evening, everyone. Greetings from SAMVAD, a national initiative on child protection and mental health established under the aegis of the Ministry of Women and Child Development, Government of India, and located in the Department of Child and Adolescent Psychiatry at the National Institute of Mental Health and Neurosciences, Bangalore, as in NIMHANS. We are delighted today to warmly welcome honorable judges of the Supreme Court of India and state high courts, directors and faculty of state judicial academies, judicial officers from around the country, in particular, judges of special courts and children's courts, and juvenile justice magistrates, all of whom we are especially special because they work to implement child laws. Also, child mental health service providers, child protection functionaries, researchers, academicians, and students who are attending this session. A landmark legislation, the POCSO Act, is not only the first and only child sexual abuse law in South Asia, but also one that recognized the need to differentiate between sexual offenses committed against children and adults, including the need to expand a range of various forms of sexual offenses and institute special provisions for safeguarding the interests of child sexual abuse victims when they engage with the legal system. It has thus been a timely and powerful instrument in consolidating the child protection mandate in our country. Over the years that followed its enactment, innumerable training programs, capacity building initiatives have been held for various stakeholders and duty bearers, particularly from the domains of child rights and protection, mental health, law, and education, to name a few. Personal safety and awareness programs for children in spaces such as schools, childcare institutions, and so on abound. Numerous public discourses in academic, professional, and judicial spheres have taken place with discussions centered around a range of dilemmas that have emerged in the implementation of the law, namely those pertaining to mandatory reporting, adolescent consensual sexual relationships, the trauma of child witnesses having to contend with the adversarial justice system, so on and so forth. 12 years on, however, we feel that it would be both interesting and important to trace the history of the law and its drafting by hearing from some of the members of the POCSO drafting committee. What was their thinking as they tackled this fascinating and all-important task of developing a legislation for some of the most vulnerable populations in the country? How did they imagine that the law might be implemented? What were their hopes and dreams for how it might be used to protect children? What were some of the dilemmas and debates that dominated the discussions of the drafting committee? Looking back on the objectives they had in mind whilst drafting the law and how the law has played out in practice, what do they feel are its achievements and gaps? In order to shed some light onto these questions, we are very fortunate to have with us a very experienced and erudite panel. We have our chair for the evening, Honorable Justice Madan Lokur, former Judge, Supreme Court of India, and former Chairperson, Juvenile Justice and Child Welfare Committee, Supreme Court of India. His Lordship hardly needs an introduction, particularly amongst our audiences today, wherein he is not only known and respected, but regarded with much affection for his enduring interest and commitment to child law issues. Welcome, sir. And some of the members of the POCSO drafting committee, namely Dr. Shanta Sinha, a leading child rights activist of our country, the founding secretary of NGO MV Foundation, is widely recognized for withdrawing over 1 million children from work and mainstreaming them into public schools. As the two-time chair of the National Commission for the Protection of Child Rights, ma'am has worked extensively on child rights issues ranging from education, violence, abuse, child labor, corporal punishment to juvenile justice. She has served as professor at the Department of Political Science, University of Hyderabad, and is the recipient of many prestigious awards such as the Albert Shankar International Education Award and the Ramon Magsaysay and Padma Shri Awards. The POCSO Act was in fact drafted under her chairpersonship at the NCPCR. Professor Babu Matthew, as Professor of Law at the National School of India University, combines teaching with the practice of human rights and has been part of several social movements ranging from the trade union movement to those on bonded labor, child labor, displacement and destruction of the livelihoods of the marginalized. Ms. Vrinda Grover is an advocate at the Supreme Court of India, a lawyer, researcher, and human rights and women's rights activist. She has appeared in prominent human rights cases and represented women and child survivors of domestic and sexual violence, victims of communal massacre, extrajudicial killings, and custodial torture, and other vulnerable individuals from sexual minorities, trade unions, and political activists. And finally, our very own Dr. Shekhar Seshadri, former Director and Dean Behavioral Sciences of NIMHANS, former Head of Department of Child and Adolescent Psychiatry at NIMHANS and advisor to SAMVAD currently. In his capacity as professor and child psychiatrist, has pioneered both in the area of child mental health and child rights in the context of child sexual abuse, as well as juvenile justice, also highlighting decades ago the need to develop methods for children's interface with the law. Welcome to our esteemed panelists. We look forward to your sharing your thoughts and insights this evening. As we begin this session, we request our august audience and viewers to please use the YouTube chat to put your comments and questions. Time permitting, we will do our best to take some of these towards the end of the session with the permission of the chair. And so, without further ado, I hand the session over to our chairperson, Honorable Justice Madan Lokur. Thank you.
Yeah, thank you, Sheila. And first of all, I would like to congratulate SAMVAD for this initiative. I think it's a great initiative where everybody is present to discuss something very important as the POCSO Act, its origin, and we'll be discussing about its future as well. So thank you to all the panelists. I will not repeat the welcome that has already been accorded to you and get straight down to business. The first question that I would like to ask is to Shanta Sinha and Professor Shekhar Seshadri. The question is that, you've had a lot of experience in dealing with the rights of children and problems that children have had. So while you were discussing the drafting of the POCSO Act, you would have, of course, apart from your experience, considered a large amount of available material. So what really was in the back of your mind when you got involved in drafting the law? And since it was, at the instance of the government, what was at the back of the mind of the government? What did they intend? What did they want you to focus on? Why did they want this kind of a law and have this mandate? So just a broad sort of an overview, if you could give your views and what you think were the views of the government at that time. May I begin with you, Shanta? Shanta, you'll have to unmute yourself, please.
Thank you very much, Justice Lokur, and also Professor Shekhar Seshadri for giving us this opportunity to take us back to a decade or more, and recalling what happened then gives us some kind of energy to talk about POCSO. Now, let me tell you that when I joined the commission, there was a huge discussion on the study on child abuse in India, 2007, and alarming statistics that emerged that at least some 90% of children were subject to violence, and most of it perpetrated at home. There was corporal punishment in the schools and teachers, and 58% of children were victims of sexual assault, which was really alarming. And also that most of those perpetrators were not strangers, but known persons. Now, this kind of report generated a lot of discussion, and I think provoked the ministry also to come up with a law. And they started to have an omnibus bill on all forms of violence of children and drafted a law on ending violence on children. That draft came to the NCPCR at that time. Simultaneously, in NCPCR between 2007 and 2010, it heard several complaints regarding sexual violence and sexual assault on children. It was very, very revealing. There were children who were hardly 2-year-old who were subject to sexual violence. There were violence on 4-year-olds. There were violence on girls. And some girls were so strong. They said, we will stand by, we'll go to the court, we'll fight, we need support, but we are going to testify because we did no wrong. No, that also gave us a lot of courage. But what we found, two things. One is that there is no age bar to have violence over children. It could be an infant, it could be an 18-year-old. And there is no age bar about perpetrators. It could be an old person and a young person. And there is no age part about gender also. It could be a boy or a girl as a victim, and even the perpetrator could be a man or a woman. These are the things that became very revealing for NCPCR. More than anything else, there was no system of justice. No action could be taken because there was no law that could address these issues. So when this omnibus bill came from the ministry, we felt that it was incorrect. There has to be a special act for addressing offenses against children and sexual offenses against children, and it cannot be included as part of an omnibus bill. Of course, we will go into the details of specificity, otherwise I'll be taking up all your time. But I must tell you that we did make an appeal, and Professor Babu Matthew helped the Commission in drafting this appeal to the National Advisory Council, where we made an appeal to them saying that this is wrong and there has to be a special act for addressing offenses against children, because it's not just about criminal justice system. It requires rehabilitation, it requires restoration, it requires support persons. I will not go into this, but all these details are already there in the Act. But then when you deal with child-related jurisprudence, it has to be a comprehensive act, especially if it is a sexual violence. And why is sexual violence different from other forms of violence is also what we justify, saying that it has silence, unspoken word, moral pressures, power relations that are on. And so you have to facilitate the entire process of justice, and therefore it cannot be included with all forms of violence. Having come to this, we were happy that the NAC, in fact, directed the Ministry of Women and Child Welfare, saying that authorizing the NCPCR to come up with a draft. And I think we were fortunate to put in some of the best minds in the country with again, the panelists. In the panel, we have Vinda Grover here, Babu Matthew here, Chowdhury. There's so many activists who participated in this. Shekhar Seshadri is also a professor who put in their mind to develop a draft bill on the commission for protecting children against sexual violence. I'll stop here. I don't want to take more time. Thank you, Justice Lokur.
Yeah, thank you. Yeah, Dr. Shekhar. Yeah.
Yeah. So here's the thing. Even before this drafting committee was constituted, 15 years before that, we were seeing cases of child sexual abuse in the clinic, assisting them in their trauma, trying to understand the impact it had on them. Some of these cases, an FIR was lodged. We had to go to the court as expert witnesses. There were issues and complications there because we existed then at a time which I can best define as the culture of denial and the conspiracy of silence. At that point of time, the late Sheila Barse actually organized an international conference in Mumbai. This is much before the law came into being. The conference was on child protective trial procedures and prevention of secondary traumatization in court processes. And interestingly, two things were said at that point of time. This is pre-POCSO, mind you. How do you expect a child to narrate in exact detail the sequence of what's happened, which are quite horrific, quite inhibiting, in the presence of a full-time defense lawyer and in the presence of the accused? I'm talking about pre-POCSO. And people in that, even the best of us adults, cannot sustain courage in the face of this kind of an approach. By that time, the Sakshi versus Union of India, the Jaku case, was also going on. And here is what happened. An 18-month-old child was sexually abused using an object or the fingers. And here was the argument of the defense lawyer based on IPC. He said, what abstract notion of modesty does an 18-month-old child have? So 354 is not satisfied. In any case, penile penetration did not take place, and asked for an acquittal based on this argument. Of course, better sense prevailed, and the man was prosecuted. But you can see how the limitations of the law can basically obscure what is a brutal act. And this was kind of scenario in which mental health professionals like me, who were dealing with the issue of how to gather evidence on a case, how to assist a child in court processes, how to look at other forms of abuse which were limited by the then prevailing IPC, the 354 and so on, to basically suggest that we need an expanded version of the law to basically take into consideration all forms of abuse, non-contact, contact, and in contact, non-genital, genital, in genital, penetrative, non-penetrative, and penetrative, assaultative, and non-assaultative, and so on, so that justice is done to people whose lives are disturbed even by non-contact forms of abuse. And so this is the kind of thinking that we brought in from our experience of working in child mental health into the deliberations of the committee that was set up under the chair of Dr. Shanta Sinha. And I was honored to be in that committee with Ms. Vinda Grover and Babu Matthew and many others who were part of that committee. So Justice Lokur, this was essentially the kind of background in which we needed to really examine the law as it existed then, and what happens to a child who undergoes abuse, maybe once, maybe several times, maybe with a single perpetrator and multiple perpetrators. And then what happens in the trial processes? And even now, with a case coming to be known with an FIR and 161 and 164 and charge sheet being filed and the charges being framed and the case coming to trial and direct and cross and argument and the duration that it takes, what really happens to a child in this process is also something that we are preoccupied about. In hindsight, I wish that we had thought about a lot of this when we were drafting the law. And later in the session, perhaps I'll share some of the ideas that we have going ahead as to more changes that are required to conscientize the law even more so that true justice is done to people. Justice Lokur?
Yeah, thank you. It seems to me very clear that from what Shanta has said and what Shekhar has said, that you were initiating some kind of a mini revolution, in the matter of child rights. All right. And that mini revolution would have had some consequences at some point of time from society, from the courts, from the government also, for that matter. So, as a follow up to that, because you had mentioned about court procedures, as a follow up to that, I would like to ask you, Vrinda, and Babu Matthew soon after that. Did you encounter any problems, in drafting these child-sensitive procedures, for example, or the infrastructure of the courts is such they're not child-sensitive, they're not child-friendly at all? And did you encounter any problems in that, from the establishment, that is the government, or from the judiciary, or generally from anybody else? Vrinda, can you take that first?
Well, thank you, Justice Lokur, and good evening, and thank you, Samvad, for this. It's so wonderful to revisit this process. I remember 2010 when we were engaged in this, and one of the reasons why this gap in law was staring at everyone in the face was also because otherwise, particularly for boys, the only space under the Indian Penal Code was Section 377 of the IPC if any sexual assault takes place. And in 2009, the Delhi High Court Nas Foundation judgment had already come, seeking the reading down of 377, creating an even larger gap in law. In terms of the process, as was mentioned earlier, as chair of NCPCR, Dr. Shanta Sinha had invited all of us. There were two committees, if I recall correctly, one looking at substantive offenses and one looking at procedural matters. I think Justice A.P. Shah was chairing the committee of which I was a part, the substantive offenses committee, and I think Babu was part of the procedural aspect. There were actually, and please correct me if I'm wrong because it's really been 12 years. One, I think what this the meeting reminded me was that there was a time not so far back when lawmaking was an inclusive, participatory, consultative process, which was not happening only in the ministry, but also NCPCR as an autonomous statutory body was engaged with it. There were two simultaneous processes where the ministry prepared its own draft, the Ministry of Women and Child Development, and NCPCR prepared its own draft. And there was an exchange of the drafts, and there was conversation between the two. I must say we were given absolute freedom, and we had very rich conversations, debates, disagreements, and it only helped to strengthen whatever was put together finally. Of course, what would prevail is the ministry's draft, and that's the one that then got introduced in Parliament. And amongst the things that, at least in the substantive aspects that I recall very clearly, which we wanted to push for, unlike the IPC, the naming of offenses is very different under POCSO. they're very overbroad. It says penetrative sexual assault, sexual harassment, and we were keen that there should be fair labeling and precision in naming the offense, which unfortunately we totally lost out on. And the law as it stands today has these very broad categories called sexual assault and penetrative sexual assault, which is actually not even the way Indian jurisprudence, the legal jurisprudence in India had till date developed. The other aspect, which I assume will become a point of conversation later in our discussion today, was on mandatory reporting. If my documents which I dug out are accurate, the NCPCR draft did not recommend mandatory reporting at all. The mandatory reporting came exclusively from the ministry. And I think it's important to say that, because for too long, NCPCR has been burdened with this. It was not a suggestion in the NCPCR draft at all. The third important thing I would say is that in terms of I'll leave the procedural aspect for Babu to tell us, because he was more in that committee. But in terms of the age, which again is a source of much controversy today, including in judgments of the court, we had suggested that there be what is known as the Romeo-Juliet or the young adults defense, that particularly when it comes to 16 to 18, the statutory rape will not be considered, and there will be certain 9 circumstances in which, if there's force, coercion, intimidation, impersonation, etc., then it will be a case of rape or assault, but otherwise it will not be if the two are between the ages of 16 to 18. Of course, on all these three, we lost out completely.
Thank you, Vrinda. Babu, would you like to add to that?
Yeah, thank you, Justice Lokur, and thanks to all the earlier speakers who made my part of the work more easy. But I certainly want to make a few general observations, having been a part of this very educationally valuable process. First of all, I want to, mention that even among us, there was debate whether we need a special legislation, or is it better to think in terms of amendment to the IPC and the procedural laws. And we couldn't resolve that debate among us. What we did was, let's put it on hold. And let's see at the end of having completed this drafting as to which way we should proceed. And I must say that by the time we had completed the drafting, the original question had disappeared. So in a sense, that also reflects the quality of the drafting process and everything that went along with it. Another thought that has never left me is, to move away from the Indian Penal Code was not easy, subject to, the caveats entered by Brinda during the conversation already. But I do recollect that, when women's movement asked for changes in the law relating to sexual offenses, the Home Ministry would oppose it tooth and nail. And I think this time, when it was women and child development, which was pushing virtually the same agenda, I thought it had a better receptivity at all levels. And that indirectly has helped us. We must never forget, however, that the grounds was prepared by the feminist movement and their more systematic attack on all these fronts. Then I think, there was this huge burden that the ordinary criminal justice jurisdiction simply overtakes everything else. And how do we try and move away from that framework in order to achieve what we wanted to? Certainly, it was an uphill task. And Brinda has referred to the dynamics of that between the NCPCR and the Women and Child Development, and the fact that there was two drafts throughout. But it is interesting to note that that barrier was broken by the parliamentary committee. We also appeared before the parliamentary committee, and they in fact looked at both the drafts. And at the end of looking at both the drafts, the parliamentary committee asked government, why don't you work on the NCPR's draft? And I think that also facilitated our journey forward. Having said that, let me jump into the procedural part, how to create a child-friendly atmosphere in this whole process. There, my own experience with the Center for Child and the Law, situated in the National Law School, Bangalore, and having the advantage of Shekhar Seshadri in NIMHANS. So we have had a lot of continuous interaction. And so that ground reality helped us. And one of my colleagues, Anurupa, who was then in Center for Child and the Law, we called her on deputation to National Law University, Delhi. And for 6 months, she did research on the part that was dealing with procedure. And in that process, we looked at the jurisprudence available in 14 countries. And we drew the best of experiences in order to put across what is now in the statute. Broadly, it was in relation to the recording of the statement of a child, the 164 statement, and then the medical examination provisions, and of course, the setting up of a special court. This was very good debate. There are many who pointed out, you may call it a special court, but finally, is the sessions judge who will be designated in order to act as a special court. To what extent is there a conducive atmosphere for the development of child-friendly jurisprudence? I think that remains an important question for the future also. So that's an aspect, I think, which we must give some attention to. I come from a labor law background and a trade union background. And so I always remember the Labor Appellate Tribunal of the past. And sometimes they contributed in a big way to the evolution of labor jurisprudence. So from that point of view, I'm somebody who's sympathetic to the tribunal system insofar as that kind of development of jurisprudence is concerned. So then we also went into how the court should be child-friendly. Above all, not allow the usual type of cross-examination of a child. And so we have provided that even if there are questions to be asked to the child, it should be by the judge and not by the cross-examining lawyer, and that there should be frequent breaks and a child-friendly atmosphere should prevail, and the identity of the child should be maintained. A proceeding should be in camera. It might on special occasions even be in a place which is not the regular court. And the leading principle in a sense was the child must never be brought into eye-to-eye contact with the perpetrator. And so I won't say more than that. Each of these subheads have been elaborated very much in the relevant chapters 5, 6, 7, and 8. And I think that's what makes this law very special. Thank you, Justice Lokur.
Yeah, thank you, Babu. That takes me to, from what you have said, Shanta, and what Vrinda has also pointed out. Over the last 14 years, there have been some concerns in the implementation of the law. One of them, which I did not know, that the NCPCR was against this idea of mandatory reporting. But it seems that you were overruled on that. But anyway, mandatory reporting is one of the concerns. Doctors, don't want to report because the family says don't report. But the doctor says, well, what can I do? I'll get into trouble, right? And now there's also a judgment which says that, well, you have to report whether you like it or not. That is one. The second is that, consensual adolescent sexual relationships. Now, we call them romance cases in some places. We call them, love cases in some other places. But this is a ground reality, all right, which Babu Matthew also has mentioned, that you can't overlook ground realities, and these are certain concerns, all right. The third one, which Dr. Shekhar Sheshadri had also adverted to was about mental health issues. The re-victimization, so to speak, of the child. Okay, the trauma that goes, in the mind of the child, and how does one address it? So this really is an open question to all of you. So you can just pick and choose, whatever you would like to say on any one of these topics. Yeah, Shanta.
Yeah. I'll start with the issue of mandatory reporting, where even now I think it's a very problematic issue and it should not have been there at all. As you mentioned, that there is an issue of confidentiality, especially when you talk about hospitals and doctors and psychiatrists. They do it in trust and in confidence that they will be not harmed on this, or there won't be any disclosure of information that is shared with them. I had a call soon after the law was passed from a psychiatrist in Kerala. He says that he is actually counseling 10 girls from a particular school, and he wanted to know uh, how can I abide by the law in POCSO, and I cannot do it because these girls have come to me with great amount of confidence, and how do I mandatorily report on this? I, I had no answer, but I told him, you flout the law. Doesn't matter. Children are more important. Their conditions are more important. We'll have to fight this battle at some time, but then you don't have to abide by a law which is so unethical. That was my activist kind of a response, and he was quite happy with my response. Then also school teachers, hostel wardens, there's so many of them, they know these things are happening, but even in the mandatory reporting, there's no procedure laid out on how do you report, what is the evidence, how do you go about it? Nothing. So I think this mandatory reporting had to be totally ignored. It brings peril to children, it brings peril even to the professionals who are responsible for children and their well-being. So I would say that this was, I do not know how it came in at all, but it should not have come at all. And this is experienced in not just India, but wherever I think mandatory reporting has been condemned. About consensual relationship, this is the second thing. In fact, it is surprising, not surprising, it's quite shocking that the POCSO Act, which has so many good provisions, even as it is, and even as NCPCR critiqued it, none of those are being heavily debated as much as this particular issue. And it has been misused as if the POCSO Act has come into being to penalize children between 6 to 18 years, 16 to 18 years. That was not the purpose of the Act at all. It had to be actually in supporting adolescent children and their sexuality. It had to be supporting their exploration of their sexuality, which is so normal. And here you find something that is so abnormal that comes into the act and that punishes children for doing something so very normal, and there's no way of getting out of it. In fact, you find that even in the practice that I am working on adolescent girls and boys, I find that they constantly are falling in love, and there's constantly a case against the boy, and the way we are resolving it is that by educating and saying, let's not criminalize it, let the boy go back to school, let the girl go back to school, and resolving it at a community level and not getting the issue come even up to the police station. But I think this is the greatest harm that has been done, and it has to change. And why don't we just ignore? I think sometimes when laws are wrong, I do not know. I'm again an activist speaking. I can't speak like legally that voice. But this is a wrong thing, totally wrong, totally messed up. And it should not be there. There has to be a loud voice. And perhaps because we have audience of the judiciary, the magistrates, all of them who have to go by the book. I think they have to go by the spirit of the law sometimes and not by the book. And that is my plea to them. Do not criminalize these young boys who are just 16 and 17 and 18 for doing what all of us did when we were young. And the third thing that you have raised is about the mental health. I think Professor Seshadri is best to talk about it. But here I would just like to say that a child is a being, and that being is being traumatized, is being victimized, and we have to do everything to see that the child becomes a confident adult, an adult with agency, an adult with self-esteem, and the law must provide for how this being becomes an adult with agency. And if there is the process of law, again, as Professor Seshadri had said in many instances during the consultation, should be a process of healing. By the end of the procedure, the child emerges as a child who is confident, with self-esteem, who is healed. And in fact, the child should have the confidence to say, I don't need any support persons. I will speak for myself. I have the confidence to do that. I think that should have been the process in which one would have gone through, where the trauma is not stuck for good. And I again, I would say Professor Seshadri is the best person to talk about the third aspect. This is what I have as preliminary remarks.
Yeah. Okay, Shekhar, would you like to take over from there?
I'll just segue from there. Just a little bit on mandatory reporting. Nowhere in the law does it say that if I get to know that I'm obliged to report within the next 1 second. The law does not state that. In fact, there is no time frame for that. So what we have done in SAMVAD, particularly with the work of Sheila Ramaswamy, the technical and operational lead of SAMVAD, is we have an 8-step process by which we address the hesitations and reservations and fear that children and families have about mandatory reporting. And we use this framework to then take them to a step whereby they are comfortable, they are convinced, they are courageous, and they see the necessity for reporting. And if at some stage they are not ready, at least the intention to report is so documented, in case people who come to know, teachers and doctors, are afraid of being prosecuted, at least your intention to report is documented. But we have this 8-step process, and we'd be happy to share this with the many people who've come on this program. It has in fact been published in the Asian Journal of Psychiatry, and we are happy to share the link. The second issue, as far as not criminalizing consenting, loving adolescent relationships are concerned, and Shantaji's sentiments here are so evocative. I must share with this audience that every year the Supreme Court of India holds a consultation in the premises of the Supreme Court on the JJ Act and other and POCSO and so on. And last year, in the consultation that was held in Supreme Court, the whole discussion, including the Honorable CJI's address based on the Vidhi report, was on decriminalizing, on not criminalizing consenting adolescent relationships, and we are completely in line with this thought that loving, consenting relationships should not be criminalized. And I think people in the judiciary must understand and take a more compassionate, a more empathic, a more understanding approach from what adolescent development means in order to support the growth of these people into the sensitive, loving beings that they already are, instead of pathologizing it. The last issue here, about the secondary traumatization and re-victimization that occurs in court processes, is there are a couple of things I want to share with you. For those of you who are familiar with the Muzaffarpur case, Justice Madan Lokur was still in service then. And when he passed an order instructing the CBI to investigate the case and passed an order instructing us to assist the CBI in this investigation, friends, we must understand that one child abused once by one person, known or unknown, and we are trying to investigate, assist means one thing. 47 girls abused over a 3-year period by multiple people, known or unknown is completely different. Which incident are you gathering evidence of, and in how did they depose? And anyway, Sheila had basically headed the team there. We submitted a 150-page report that was filed along with the charge sheet, and the case was shifted from Patna to the special court in Saket. And 3 of us were prosecution witnesses. Our direct and cross went on for 3 days because there were 22 accused and therefore 21 defense lawyers. And the judgment, as you know, came in December of 2019 and the sentencing in January of 2020 before the pandemic hit us all smack on the face. And you know that 11 people were sentenced to life for the rest of their lives. But that's one part of the story. The part that I wish to emphasize is that SAMVAD has been working on developmental and mental health implications of evidence gathering under 161 and 164. So we work extensively with the police systems, with both the National Police Academy in Hyderabad and state police academies, as well as with the state judicial academies, with the special court and POCSO judges, to basically train them in how these kind of processes can be conducted in such a way that the trial processes are not traumatizing. As Shantaji said, the whole process is healing, so that you don't have a child who said, I won the war, but I lost the battle. Yudh jeet gaye, lekin jang haar gaye. And what was the point of it all? And why did I have to endure all of this? So SAMVAD has a training program, which we are happy to offer to, and we're already doing this in many of the state judicial academies, so that all these processes keep in mind a fundamental premise of preserving the mental health of the child. And the last thing I want to say is we've often had the consternation of a well-meaning IO sometimes telling us कि हमें evidence दिला दीजिए, आपका counseling तो चलता रहेगा. And we say, देखिए, the child is admitted with us for rest and relaxation. Next, if the child has issues to discuss, we would like to listen and address. Third, we want to understand what happened and assist the child. We'll also document what is required. And fourth, we will help you in the process of evidence. Not necessarily one after the other, they can be launched simultaneously. But we need to understand what trauma means for a child and how these trauma processes actually continue through these legal processes, so that we render all the experiences that children endure in this whole saga and narrative that plays out in a manner that is healing for the child. Justice Lokur?
Yeah, thank you. This idea of trauma or agency or mental health aspect, I think, is now gaining currency in the courts. And I would just like to say that the recent decisions that have come from the Supreme Court on abortion, have taken this aspect into consideration. But anyway, Vrinda, would you like to add, from your personal experience and from, the experience of your colleagues, what do you have to say about these things?
Thank you. These are fascinating. I mean, listening to both Dr. Shantasena and Dr. Seshadri is fascinating. And on the aspect of mandatory reporting, I hear what Shekhar Seshadri is saying about, how do you find this space within the law? But it is having a chilling effect. It's actually causing a lot of fear and alarm. And while I understand that, persons you are engaging with are able to document, which can perhaps assist at a bail in a court, etc. What is happening is that we also have judgments where school principals and others are have been convicted by courts. We have you may be following a certain timeline, but you can have the police which will hold someone, name somebody in an FIR or say, I think you are also an accused. Not the direct perpetrator, but the head. I'm presently, I was giving legal advice to someone where a young schoolboy was sexually harassed by others within the school for being gay, and he commits suicide. The school principal is being prosecuted for not taking, and the school principal was made aware of what was happening. The school did not take necessary measures, but now their school, because the school principal is being arraigned as an accused, the school is saying, well, the mother knew also. So the mother should also be an accused. This mother who has lost a child who has committed suicide due to being sexually targeted by his peers is today a potential accused for failing to do mandatory reporting. The law has become totally, it's broken all bounds now. And I think there's an urgent need to stop here. We also need to reckon with the fact, Shekhar Sheshadri mentioned Muzaffarpur, Justice Lokur was on that bench. I was representing TISS. And we know that the mechanics of mandatory reporting did not help. It was the TISS report which actually flagged what was happening in the home in Muzaffarpur. So my experience shows that, and counselors at school, women's organizations receiving a call from a minor girl saying, this is happening, but please don't tell the police. Now that NGO is asking, what do we do? And what people are therefore doing is saying, don't come to us then. And I think what we need to do is definitely call for exemption of certain categories, even if the government is not willing to get rid of it, because I don't know whether it's ever served its purpose, but definitely ask for exemption of categories of counselors, doctors, etc., NGO workers. As Justice Lokur said, in the Miss X versus Principal Secretary and Family Welfare Delhi, the Supreme Court judgment is already recognizing that medical services of abortion will not be accessible by a minor rape victim if her identity and mandatory reporting, and that is made compulsory, and that is the experience of doctors, medical doctors providing treatment to victims of rape and sexual assault across the country. So we need to at least start asking for exemptions and let it be there for institutions like children's homes, prisons, etc. In terms of the 16 to 18, actually there have been some very interesting innovations. In Tamil Nadu, the High Court asked for all these, they asked certain districts of the police to give them all the cases relating to 16 to 18. And they appointed an amicus. Again, inclusion of activists and those working in these areas, experts, is helping the court. So an NGO in Chennai was asked to assist. And now what they're saying is, instead of arresting, issue a section 41A CRPC notice in lieu of arrest. Because if a case, there is an FIR, even as investigation is going on, arresting a boy, putting him in a juvenile home is already, you are causing huge trauma to somebody, because in our country, we refuse to acknowledge and come to terms with the fact that young people are sexually active. And this is a cultural problem, and we don't want to acknowledge it. And so we are penalizing. And of course, there's this whole thing about women and young people exercising sexual autonomy and making romantic choices not based on certain dicta of society. We also have the Law Commission 283 report, which is offering some, saying give discretion, but not for removal. About 5 minutes before this webinar was to begin, there is just a judgment of the Odisha High Court that has come in, where a large number of cases went to the High Court, saying that the culture in Adivasi communities is very different. What is this 18? This is not the practice. And what is therefore happening is that you are arresting people. We saw this, we saw the weaponization of POCSO not very long ago in the state of Assam, to say that we need to curb child marriage. And we know that that's not the way. Child marriage is falling, but there are other ways in which the state can intervene. So I think insofar as 16 to 18 is concerned, then, and any judicial officer who has held a POCSO court will say this. And I have been to state judicial academies where they are saying, Dr. Sheshadri, you said they should be compassionate. They are finding the most innovative ways to not allow this kind of penalization and harsh sentencing to happen, but they are bound by the law, and then it becomes very difficult. So all judicial officers, I think some kind of reports need to be brought out. What is their experience? And that is the evidence on which the amendment to this law needs to be made. It is not in the best interest of the child. Our validation of the Convention on Child Rights does not require us to keep 18 as the age. That is a completely misinformed view. The same harassment is happening under the Indian Penal Code. We really need to humanize our law and delete this 16 to 18. I'll take half a second more on the, and there are today, as we know, a lot of what has been set up as vulnerable witness courts across the country. Every district is required to have one. I don't know what is the status of that. There was a judgment of the Chief Justice directing this. Delhi was a front runner in that already. I don't know what Dr. Sheshadri has greater experience and expertise in this. My experience of representing children in these cases is that, and I know that the mental health, even professionals in mental health will sometimes tell parents, don't go in for litigation, don't take the child to court. My experience has been that if, and it's a big if the process is enabling, it actually can be therapeutic, and I may be using too big a word here, but it can help the child overcome the trauma, provided the manner in which that hand-holding is done, the guidance is done, and the court conducts it. You don't need to be extraordinarily, nobody needs to be, I think our judicial officers actually have a lot of experience. It can help a child, because I remember representing a child who said, I want to put the bad man into jail. And at the end of it, that child has emerged actually stronger. Of course, the child was getting a lot of support, including mental health support. I will stop there.
Yeah, thank you, Professor Matthew. Can you share your experiences and thoughts on this, please?
Yeah, I would want to invite everybody's attention once more to the question of how do we develop child-friendly jurisprudence in a more sustainable manner. I think it is now a form of ad hocism that we are witnessing. I don't think we even take systematic note of those decisions which are very much child unfriendly. I once again draw my inspiration from what has happened in labor law. For a case to reach the Supreme Court, it takes so many years. And so no individual worker would ever be able to take that journey successfully. It's the trade union which provides the vehicle for it. Of course, with all the limitations of the organized sector, those same issues are becoming even more glaring when we are looking at the informal sector. So many critically important issues arise there. And that is a parallel to what we are talking, because those children who are at risk to the highest degree are the children of the excluded and marginalized communities. And so when you look at the informal workers, that's where I find these references coming up again and again. The National Commission for Enterprises in the Unorganized Sector pointed out that if you look at the total number of workers in the informal space, then 85% of them come from these marginalized communities. Our base unit of institutional arrangement is the Juvenile Justice Board, but that is created only under the Juvenile Justice Act. And in that sense, it's not a comprehensive base unit. Where do children go for that? I don't think that so-called child-friendly court that we have created at the district level is any substitute. So we need to ponder over an institutional arrangement whereby cases of children in difficulty is taken up, and that might require a creative revisiting of the present hierarchy. especially remembering that, all said and done, the major inarticulate premise of a judge is what determines the judgment he gives. And keeping that in mind for the days ahead, I think we must think in terms of depending more on sustainable institutions that draw inspiration from below and are processed at a higher level. I leave it there.
Yeah, thank you. Shanta, you had used the word spirit of the law. We talk about the spirit of the Constitution when we talk about fundamental rights, for example. Now, Professor Matthew has mentioned, Vrinda has also mentioned, Dr. Shekhar Sheshadri has also mentioned about, the legal system being a sort of a maze, which people want to try and avoid. If they can't avoid, they get scared of what is going to happen and so on and so forth. Time, it takes years, takes a lot of money and so on. So looking back, right, and also looking forward, do you think the first of all, what is the spirit of the act? Okay, and has that in some sense been achieved? And what can be done to achieve this spirit of the act looking forward?
I do not know if I have an answer to this, but I can only say link it to the issue of a right of a child for justice. That is the spirit of the act, I would think. That every procedure that has been laid out for justice should be seen as a right of the child. And wherever there has been a compromise, that right of the child has been compromised. Right from the stage of recording of the statement to the medical examination, to the cross-examination, to the rendering of a justice, at each stage, whatever has been given as protection systems to the child is a right. And I think that right has to be protected. And if that is compromised, then the entire process is compromised and the child's right to justice is lost. I would go by a rights-based framework on this. This is slightly off tangent when we are discussing 16 to 18, but I think even the Juvenile Justice Act has criminalized children between 16 to 18. So when we talk about 16 to 18 and POCSO, it cannot be read separately from what is happening in the Juvenile Justice Act also. We have to start interrogating that and the political context in which that emerged. The entire Nirbhaya had criminalized the young man, and the young people in the country, and has forgotten what happens to the kind of research that has been done in the development of the brain of the adolescent boys and how impulsive they are. Nothing of that sort has been even taken into consideration. I would believe that when we are talking about 16 to 18, one would have to simultaneously talk about what is happening to the perspective on adolescent children, even in the Juvenile Justice Act. Yeah.
Yeah, thank you, Vrinda.
Completely agree with what Shanta is saying, and this whole thing of transfer to the adult system is actually a violation of the principle of law. And I think what has happened is, yes, there is a lot of crime. Yes, there is anxiety in society when there is crime, but our response to pervasive crime seems to be that we are going to put young people, we are going to put young men in particular, not just young people, and those young men will come from the fringes of society. The others will be able to find ways in which lawyers and others will assist, facilitate them to exit the legal consequences. And the answer seems to be lying only in incarceration. And I think that is really at the heart of where the problem has begun, that everything has to be seen. The solution is not the criminalization. As I see it, POCSO sets out what the offenses are and says this is a wrong. The purpose of the law is to deter, is to be preventative and have some fear. the law, if it's only going to fall on certain sections of society with all its viciousness today, and is not going to A, bring down crime at all, and B, is not going to resolve anything. Actually, taking off from what Babu said, there is a very large number of children of the working class who suffer a range of sexual violations. POCSO may not come to their aid. Maybe creches will come to their aid. Where are the creches at the work sites? How are women, how do women live? Pick up any POCSO court cases, and you will find cases of children of working class parents who have been left under the care of an elder sibling, and who are then subjected to all forms of sexual violence. And there are other responsibilities of the state. The state cannot say, I will give harsher punishment, I will put more people in jail. And secondly, the process in POCSO courts, Delhi is actually an exception for many reasons. But I travel for work even outside Delhi, and there is no training. There are no special prosecutors. The whole system is meant to work together as an ecosystem, and we don't have that happening. And everybody, we bay for blood too easily now in this country. And I think if today anybody was to ask me to sit down and draft the law, I would actually put not that these provisions should not be there, but how do we look at incarceration? How do we look at punishment? What do we make the responsibilities of the state? Would be very different.
Professor Sheshadri?
I do know that we run the risk and danger of shifting to another subject here, namely children in conflict with law and the whole Section 15 issue. But since the issue has come up, I'm going to try and link it with the whole POCSO situation and children between 16 and 18. Our position in SAMVAD has been fairly clear. Till such time that the law changes, we must try and retain children in conflict with law within the JJ system. We have enough provision. So our position is very clear. No child should be transferred. Our position also is every child in conflict with law was and continues to be a child in need of care and protection. If you really look at the pathways to vulnerability, the pathways that Ms. Vrinda pointed out, they come from circumstances that are... So if you look at the whole principle of proportionality, the seriousness of the offense and the seriousness of the circumstances that they come from, and apply that lens to look at what I believe is very central to the three words in the Juvenile Justice Board. There's a central word, and that's justice. Just as I always said that the central word in Child Welfare Committee is the second word, and that is welfare. So I feel that we've reached a stage in today's discussion. I also wanted to say, Justice Lokur, that we actually have almost 2,500 people listening on to this webinar. Oh. And we have more than 200 comments that have come. And perhaps we will keep this recording and do some kind of an analysis of the comments that people have put and come up with a document of people's thinking and so on. But Sheila has, I think, tried to consolidate at least some comments, which she'll probably relay for us to respond to as we go to the last leg of this webinar.
Yeah. Actually, what do you think is the spirit of POCSO? I mean, is it justice, as Shanta says? Should it not be, incarceration, as Vrinda says? What should it be? How does a judicial officer look at a case? Vrinda said that they're trying to find innovative ways to get adolescents out of these love cases or romantic cases and so on. How do you think, what really is the spirit behind the law?
Well, as far as POCSO and people between 16 and 18 are concerned, I go back to the point that Shantaji made, which is to look at adolescent, neurodevelopment. And there are some very interesting findings of how neurodevelopment has actually informed jurisprudence and forensics and how we proceed in really understanding risk behaviors and their capacity to make decisions and otherwise that. And part of what we're doing, Justice Lokur, is actually when we work with, Samvad works with training of the JJBs to really discuss issues of neurodevelopment, discuss issues of pathways to vulnerability, to lay a frame of reference. In fact, we have 7 or 8 pathways to vulnerability by which children actually come into conflict with law, of which POCSO offenses are one type of. There are many other kind of offenses that. So I think that for a lot of judges, and this is what we call as the transdisciplinary approach. It's not enough for a mental health professional to diagnose PTSD in a child who has experienced abuse. I need to know the law. I need to know all the processes so that I can assist the child in every stage to prevent secondary traumatization and revictimization. Similarly, not enough for a judge to listen to testimony and adjudicate. Who is the child? 3 years old, 6 years old with hearing and speech problem, 9-year-old with intellectual disability, 14-year-old with severe incapacitating post-traumatic stress disorder. So a judge needs to know developmental and mental health implications of evidence gathering and how court processes are actually conducted. There are 2 things I remember very distinctly, Justice Lokur. One is what Justice Deepak Gupta told me. Justice Deepak Gupta took over as the chairperson of the Supreme Court Juvenile Justice Committee after Justice Lokur. And we were speaking about this child-friendly, and I was having a conversation with Ms. Vrinda also on this issue that, just the geography and Mickey Mouse pictures and a velvet-colored sofa does not make a child-friendly court. And Justice Gupta said, your processes are as legalistic. So how do we then create, and Vrindaji used the word sensitive, that we need to understand sensitivities of children, know what childhood is and what is a child going through that. And the second thing is something that Justice Geeta Mittal, who actually set up the Saket court and retired as Chief Justice of the Jammu and Kashmir court, told me, it's not about what to ask. We all know from a legal perspective what to ask. It's how to ask. And how, therefore, do we communicate with children and establish that bond and that channel which makes a child comfortable and to say ki haan, yahan acha lag raha hai. In fact, in the Muzaffarpur case, Justice Lokur, many of the children told her, Judge Sahab, humse baat nahi karenge. Humse directly baat nahi karenge. Humko baat karna hai unse. To be able, and this is exactly what Shantaji said, that to feel after everything is over ki, ye acha tha. I feel that true justice has been done. I liked the process. I was heard. I was comforted. Everything was done with this kind of sensitivity. That's the kind of future that we are dreaming of.
Thank you. Professor Matthew, last word, because we're running short of time and there are some comments.
I think as you were happily searching for the spirit behind this whole process, I suppose different pieces of child rights legislation end up in fragmenting the total regime, unlike what the Convention on the Rights of the Child does. And so how do we make up for that lacuna? At one stage, there was a request that we must try and move towards creating a child code so that there can be, coherent thinking between one branch and another. We have today accidentally gone beyond one particular branch, but I think the education aspect becomes extremely important, especially if you are searching for non-incarcerative solutions. And tragically, that's the one which is suffering most. I see in the government of Karnataka, all the government schools are in shambles, and privatization of schools has reached its peak. The only saving grace is residential schools. And when children are admitted to residential schools, in those schools, there are also residential teachers. I found that some of these children who come to the National Law School from a Dalit background, etc., they become natural leaders in the classroom. Otherwise, those who come from the underprivileged groups are put to trauma even in a place like the law school. So I think that process of empowering them also has to be part of recreating a comprehensive child rights program in India.
Okay, thank you. Any one last sentence anybody wants to add before I request, Sheila, Shanta, you want to say something?
No, I think everything has been said, but your question on what is the spirit of the law is the spirit of what all that we have said in so many words and terms. It is finally the best interest of the child. What it means is it has to be concretized. Best interest is not a principle, but actual action on an everyday. Otherwise, it becomes a jargon, and I think that has to be. And also his evolving capacities. That is why I said about being and becoming. It's not just today, especially in relation to the issue of sexual abuse and what we have just seen. We are talking about her today, but we also have to talk about her as an adult. And whatever we do should not leave a huge scar on her, but leave her as an empowered being.
Thank you. Vrinda, one last word? No, that's it? Okay, yeah, Sheila, over to you. Thank you, all the panelists. It's been a wonderful discussion. Thank you.
Sir, there have been innumerable comments on the issues that the panel has fairly extensively discussed, primarily relating to adolescent sexual consent and the controversies thereof, mandatory reporting, and so on. So, what we decided to do, because there are several questions that pertain to core law, we are going to make a list of these and share them with all the state judicial academies to take up in their judicial education programs on POCSO and other child laws. That's one thing. Having said that, we have 3 questions that if the chair could permit and direct, perhaps we could take some responses on. 1, should the age of consent be lowered? 2, how do we protect the rights of the children in conflict with the law accused of a POCSO offense under the JJ Act, especially the principle of presumption of innocence of the child in conflict with law, when the same principle in POCSO is reversed under Section 29? This is the second question. The third question is, what is the impact of the death penalty amendment that was introduced to the POCSO Act a few years ago? So perhaps,
Okay.
Yeah, sir.
I think, Vrinda, maybe you could take the second question, because it's really a legal sort of a question about the presumption of innocence and the reverse onus, so to speak, in Section 29 of POCSO.
Thank you, Justice. I think, again, it would be important for me to tell and share with everyone that actually this was an insertion of the ministry. It was not what was written in the NCPCR draft. The NCPCR draft simply said that, look, below the age of, for a child, there is no question of consent. So you don't need, it's a statutory sexual assault. So you don't need to reverse the burden of proof. Even under the IPC or custodial rape, what is said is that it's a rebuttable legal presumption. So actually this shifting of presumption of innocence, which we have in some other offenses like dowry death, etc., but it's always a rebuttable legal presumption. It should be very, very rarely invoked. And I think in POCSO, actually, it was not required. And the fact that consent is irrelevant per se would have taken care. And that is where I feel that in the the state's performative aspect of we are here to protect actually sometimes swings the needle to the other extreme. And presumption of innocence, a constitutional mandate in this country, should be retained. And in my view, the of the cases that come up under POCSO, even if you were to remove the reversal, you can still get the conviction where the evidence is there. It's actually it's an overkill, which creates, even when there is evidence, particularly in 16 to 18, it becomes a double burden then to counter.
Would anybody like to add anything to that? On Shekhar, you want to add something?
No, I just wanted to say something on the death penalty.
Yeah, please go ahead. Okay, that's the.
No, this is, I've had this discussion with just Madan Lokur at an ideological level. We do know that children under a certain age, the whole rape, murder issue, and I'm also aware of Project 39A of National University in Delhi, which really looks at people on death row and the circumstances of. And there is a divided opinion about death penalty. Some people, I often do this as a show of hands. Those in this audience who are in favor of death penalty and those who are against death penalty. You see that. From an ideological perspective, some of us, basically come from a position against the death penalty, but this issue was essentially came into the amendment because of the spate of very young children and the kind of brutality of the offenses that took place. And I don't think that this issue and the controversies therein and thereof have been entirely resolved. On the one hand, there is this outrage and sick feeling that people feel, and this kind of extends to even with the 16 to 18 quote perpetrators, unquote. If you're old enough to rape, you're old enough to stand trial, kind of the principle. So there is a position that people take where it comes to sexual misbehavior, sexual harassment, sexual abuse, and sexual violence, and sexual violence that is, really violent. It's a certain mindset, I think, that we cannot get ourselves about because of the very nature of sexuality. That it's a very complex and complicated issue, and I feel that it would need a lot more debate and discussion for civil society and the forces that be to really position themselves about this particular issue as far as death penalty is concerned.
Yeah, Shanta, would you like to say something about the age of consent? You have to unmute yourself. Yeah, okay.
Yeah. Sorry, I didn't get. No, I heard Professor Shekhar Seshadri speak about death penalty. I think under no circumstances we should have a death penalty. I mean, it's again, and in this context, I have a feeling something as stringent as this might even put things under wraps, because it is. Eventually, if it is death penalty, perhaps people will not even come up to speak about it. In terms of practicality, I think it would just put the issue under wraps because it will lead to a death penalty. But otherwise, also as a human rights issue, I don't see why one should even advocate for death penalty under any circumstance. Not just about children, but under any circumstance. This is not a I wouldn't say practicality, it's an ethical issue and not have it. I can't recall the details, but then I think Mr. Grover said it all about the consent issue. And we had very, very rich discussion on age and consent during POCSO. If Babu Matthew can elaborate on it, because right now I have not looked back at the 2010 emails that we have actually circulated, but I remember that we have spent at least 2 to 3 months only on the issue of age and the issue of consent and the issue of circumstances under which a child was forced to, in fact, get into a sexual relationship, and you go into circumstances and you do not go into consent at all. Otherwise, as Vrinda at that time very forcefully argued that if you say it is consent, then the prosecutor is on proving that you either consented or did not consent. And you should correct me, Vrinda, if I was right in recalling that. But we did have a huge discussion on this issue. I wish those notes are actually circulated because that is where we had basically differed from the POCSO Act with the ministry. Professor Justice Lokur.
Yeah. Professor Matthew, last word again to you.
No, I don't think I have anything to add now. In relation to this, whatever has been articulated, I also hold that same view. Perhaps Vrinda may have something more, because I think this got discussed more in the other group than the group which dealt with procedure.
Yeah.
Okay, very quickly, on 16 years, you're right, Dr. Shanta Sinha, we had actually put 7 circumstances. That in these 7 circumstances, if the rape has taken place, then even the 16 to 18 age group will not matter. And if it is not in those 7 circumstances, the second circumstances were like force, intimidation, threat, violence, etc. And if it was not within that, then that exceptional clause of exception was to be created. The same, this issue of 16 to 18 actually, the understanding in the government at that time was CRC has set the age of 18. Actually, if you pick up laws, and Justice Lokur knows this from across the world, that's not how it is read. And you have to, it's not for purposes of criminalizing children or setting the age of the offense. But it gets repeated because it comes into the 2012 law. In the 2013 Criminal Law Amendment Act, the same thing happens. Whereas at that time in India, the law since 1983 was that the age of consent was 16, which then gets raised in 2013 to 18. And I think it's important to mention here that the women's movement, the Verma Committee report repeatedly said, do not raise the age of consent. And therefore, it's very often said, oh, you asked for it. The women's groups repeatedly said, and the Verma Committee adopted that no death penalty. I've recently been doing a case. A sister has alleged that a brother has done sexual assault at some stage. She does not want her brother hung. She only wants the violence to stop and end. So the death penalty is not for the victim here. If it is it's giving more power to the state over our lives, then that's a separate debate in itself.
Okay, thank you. Thank you very much. I just want to say 2 words, Sheila, with your permission.
I was just going to request you to give us your concluding thoughts.
Yeah, I've always believed that we should introspect and look at laws. How are they functioning? How are they being implemented? Is this the way in which we wanted the law to be implemented? Right. So I think 12 years the POCSO Act has been around. I think it's time to have this, sort of a performance audit, so to speak, to see that where have we gone wrong, if we have gone wrong, what are the strengths of the law, and what are the changes that can be made. So I think this, a performance audit may or may not be the right word, I don't know. But I think the time has come definitely now with this, very rich discussion that we've had, to have this kind of an audit of the legislation, right? That will, I think, benefit everybody, the courts, the judicial officers, the citizens, and society. I don't know if Samvad can take on the task. It's going to be a huge task, but it's worth it. That's it. Thank you.
Thank you very much, sir, for your final words of wisdom. Our grateful thanks to the panel. You've given us some fascinating things to think about, much debate, much discussion on the letter and the spirit of the law, and a lot to think about. And Justice Lokur, now you really placed this enormous and enormously interesting burden on us, but I think we must take it forward for the children to see how the law is performing, and perhaps we should work with the drafting committee and you to do so. I think that would be a very interesting exercise for us. On that note, I'd like to request Dr. John Vijaysagar, Professor and Head of Department of Child and Adolescent Psychiatry at NIMHANS, and Principal Investigator Samvad, to deliver the vote of thanks as we come to the conclusion of our program. Please, sir.
Thank you, Sheila. It's not often that we have the privilege of hearing about a law from those who envisioned it. To know and to understand the imagination and aspirations of the drafting committee of a law is indeed rare. As we come to the close of an evening filled with scintillating discussions, I trust that we have fresh perspectives, alternative ways in which the POCSO Act may be regarded and interpreted even. On behalf of SAMVAD, I wish to express our deepest gratitude to Honorable Justice Madan Lokur, who has always fitted us into his busy travel and work schedules. We are ever grateful, sir, for your engagement in SAMVAD's work, and more importantly, for the cause of vulnerable children in our country. Our infinite thanks to Professor Shanta Sinha, Professor Babu Matthew, Ms. Vrinda Grover, Dr. Shekhar Sheshadri. Your wisdom, your thoughts and perspectives have surely given us ways not only to view the law anew, but ideas for reflection on the ways in which the law could better serve children in the future. Thank you once again for making time for this very important and engaging session. No session can be without an interested audience. Our deepest appreciation for the judiciary, the state high courts, juvenile justice committees, judicial academies, and to all the judicial officers. We are always overwhelmed by your interest and engagement with child law concerns, and look forward to our continued collaborations with you through sessions such as this, as well as our judicial education programs. We also thank all the mental health professionals, child protection functionaries, academicians, researchers, and students for their presence and engagement in today's session. And we hope that together we can integrate and strengthen our efforts towards more child-centric implementation of the POCSO legislation. Thank you all once again. Have a great Friday evening and a restful weekend.
Thank you. Thank you very much.
Thank you.